from AILAJ, and we thought that this is important. It's very important for us to have some kind of a discussion on the labor codes, and at least from the organization, we've had a very in-depth kind of look at all the four codes, and there is a booklet that we have come out with, and today's program is to launch that, is to release that report. The program basically will be with Avani, who's a practicing advocate, labor advocate in Bangalore, and the convener of AILAJ Karnataka. She will introduce the organization and a short introduction to the report. Following that, we'll have the release of the report, and then the speakers will speak, and after that, we can take questions. So without much ado, I'm going to hand it over to Avani. Avani Chokshi, please.
Thanks, Clifton. Hi, friends. Hi, sir. Thank you everyone for joining today's discussion. On behalf of AILAJ, I would like to extend a warm welcome to both our speakers as well as all the participants here. Before we start the discussion today, I would like to introduce AILAJ, our vision and our values. AILAJ is the All India Lawyers Association for Justice. We are an organization of legal professionals in whose ambit we include not only litigating lawyers, but also law students, law clerks, academics, as well as teachers. We were formed in 2020 during the COVID pandemic when we realized that there was a huge growing inequality in the legal profession, and we also saw a huge attack on constitutional values from the government on one side and the judiciary also on the other. So, at its core, AILAJ believes in protecting the constitutional values, the Ambedkarite spirit, and we do this through a number of methods. On one hand, we issue a number of statements whenever we believe that there has been an assault on constitution or an assault on our values, and we frame it in terms of the constitution and in terms of the law. We also have a magazine where we issue our commentary on latest political and legal events. We also have a number of events, such as the one today, where we discuss recent changes to the law as well as recent legal issues. In this context, you can find all of our previous statements, our newsletters, our magazines, and our previous webinars on our social media at Twitter, Facebook, and Instagram. The handles of these social media platforms will be placed in the chat soon after. And so you please visit these our social media and go through our previous content. Yesterday, we saw the defeat of a major assault on federalism that was it gave spirit to all of us. But we see the labor code similarly as a huge assault on federalism and on constitutional values, as well as core constitutional rights of the working class. When we look at these labor codes, I was surprised to go for a talk yesterday where a senior labor lawyer on behalf of the management, a senior management lawyer, was portraying these labor codes as extremely pro-worker. He said, through these codes, what has long been an injustice in the labor law of the country is being corrected. And in fact, through these codes, a number of rights have been given to the working class, and only for counterbalance, a few rights have been given to the management. This is a common impression amongst the litigators in Karnataka who are not familiar with labor litigation. And in fact, labor litigation is to some extent a niche. So there are very few lawyers who are practicing solely or almost solely on the labor side. In this context, we thought it was important to issue a detailed booklet where we trace out how we believe these labor codes to be extremely anti-workers. Of course, we can also go through a few points where, to some extent, maybe we can hope to push for some more beneficial entitlements through these codes. But overall, these codes are extremely anti-workers and will result in a whole-scale violation of rights of working class. In our booklet, at the outset, we talk about how these labor codes are going to push a huge number of working class outside of the ambit of law. On one side, this is on one side, this is being done through increasing the threshold of applicability. So as we see in the Contract Labor Act, for coverage, a contractor must have at least 50 contract workers. So a contractor with up to 49 workers does not have to comply with the mandate of law. And similarly, such workers are not entitled to the benefits of law, nor are they entitled to claim rights against the principal employer. So too in the Industrial Disputes Act and the Factories Act and the Standing Orders Act, throughout we see an increase in the threshold, which means that all workers in smaller establishments are going to be pushed outside the ambit of law. We have also done in our booklet a code-wise analysis of what we believe the impact of these codes will be on the working class. When we look at minimum wages, for example, uh, in the event yesterday, what we saw is that the management lawyers are arguing that floor wages are actually going to protect workers to ensure that state governments have to give at least a floor wage. But what we understand is that floor wage is going to definitely pull down the wages of workers, and it's going to have a negative and deleterious impact on the minimum wages of workers. So too the impact of these codes on the judicial precedent is yet to be seen, because as we all know, labor law is 10% maybe the statute, and it's hugely based on judge made law. So when we see, for example, minimum wage, Reptacos bread defines how your minimum wage components are to be calculated, and it traces itself to the labor conference. But now if you see the draft rules under the wage code, the component for rent is 10% of your food and clothing component. So if your food and clothing component is 5,000 rupees, your rent component is going to be 500 rupees. So these kind of absurd violations take place. We also see an attack on the rights of women. For example, I would say the Equal Remuneration Act guaranteed in 1976 equal rights for men and women to equal wages if they were performing similar work. Now, though this right is continued, a number of components of wages have been excluded from this guarantee, which means that effectively you're sanctifying discrimination in wages between men and women. The exclusions, the huge number of exclusions from the ambit of core work will also have a significant impact on workers seeking regularization, since now workers who are in, for example, housekeeping, cleaning, predominantly marginalized workers, are again placed in even a worse position. These are some of the things we've gone into. I don't want to take too long. I just want to add that similarly, some of the managements are also surprisingly speaking up against these codes, because for a small point, but with a big financial impact, which is gratuity. Gratuity, when we look at it, it was always based on basic and DA, but now I think as an inadvertent consequence, the gratuity applicability, the amount which will be received by workers is retroactively much higher, which means workers in service as on date might receive a much higher gratuity. So we need to see how to maybe take advantage of this fact and how to use this to push for a common fight against these labor codes. Broadly, these labor codes present a unprecedented attack on the working class, and we need to see it in the current political context as well. I think today's discussion is extremely important because we are having two very well-known speakers present these codes to us. With that, I'd like to request Clifton to introduce the speakers.
Thank you, Avani. Thanks, Avani, for that very brief but concise kind of introduction to what the laws are, and also the way in which I think we are looking at the laws. We'd actually want to also just release this report before we move on from here. There are two very eminent labor law practitioners with us. Mr. Partha Sarathi, who has more than 5 decades of legal practice under his belt, and most recently was also very instrumental in at least trying to protect the rights of the workers in the BWSSB reference case before the Supreme Court. We welcome him. We also have Gayatri Singh, who's again another senior counsel. Mr. Partha Sarathi Wali practices in the Calcutta High Court. Madam Gayatri Singh practices in the Bombay High Court, and many of us have had the privilege of working with her over the years. There's also another important thing that I have to say, that Madam Gayatri Singh was also a member of the a committee constituted by the Kerala government to look into options that state governments have outside of the labor code. So basically, acknowledging that the labor codes are anti-worker, and what are the ways in which any non-BJP state government can actually address some of these ill effects. She was a member of that committee, and they've drafted a report which is more than 300 pages, which has been given to the Kerala government. So we welcome her as well. We'll start. Let us just hold up the report, and I think that's the only way in which we can release it. Lekha, don't pin anyone so that we can have the picture of everyone with the report. Yeah, so this is the report. Thank you, everyone, for this. Before inviting everyone to speak, there are just a couple of points that I wanted to make. Actually, perhaps 21st November 2025 will be a day that's going to be etched in the memory of workers for a very long time. That's the day that these four codes were brought into force. Uh, all of us kind of remember that after November, there was, of course, because the trade unions raised a big voice against the labor codes. They've been doing so for the last decade. In fact, it is the struggle of the trade unions that had ensured that these laws, which were passed in 2019 and 20, were not brought into force for more than 5 years. Because of the kind of these struggles, what the state did was not only did it bring the act into force on 21st of November, but it was followed by massive propaganda in the newspaper, in the TV. There were pamphlets distributed. The Bharatiya Janata Party held meetings of workers in various parts. Their own cadre were actually deployed to try and convince workers that this was a very, very good kind of a law. Despite that, of course, from February onwards, we've seen a spate of protests of workers all across the country. The first was the 12th of February strike of all the central trade unions and other trade unions, which was also joined by the Samyukt Kisan Morcha. Basically, you had almost 300 million people in 600 districts across the country that protested on the 12th of February against not only the labor codes, but all other anti-worker, anti-people steps that the Modi government was taking. The other thing that we saw is that from February onwards, there's been a huge number of protests. What started off in one factory where you had more than 30,000 workers who struck work that day. And if you see that what began in February, towards middle February, then spread across the entire country. So you had protests from Panipat in Haryana all the way to Anandpur in Andhra Pradesh, from Bharuch in Gujarat all the way to Begusarai in Bihar. So the length and breadth of the country saw workers in emablishment after establishment. And these protests were factory-based, establishment-based protests, which now we saw again in Manesar, and then again now in Noida. And if you look at all of these protests, the basic thing that comes out is this: the frustration that the workers have at the exploitation that they faced all these years. Secondly is the LPG crisis that drove them to the wall. But most importantly, the promise that was made to them in the background of the labor codes coming into force was of job security, wage security, increased wages, so on and so forth. None of that materialized. And the workers have taken to the streets saying that what happened to your promise? We are paid 10,000, 12,000. We are made to work 12 hours a day. We have absolutely no security whatsoever. What happened to those promises that you made? So in a way, one can really say that the kind of misinformation that was spread about the labor codes, by experience now, just 5 months of experience, workers have already felt the lies, and they are starting to agitate against it. But as legal practitioners, what we felt was this report was important for us to bring it out so that people can understand why this is something that we need to be cautious about. So with these words, I now invite Gayatri Singh to first take the floor. Like I said, I'm not going to introduce Gayatri again, but she's somebody who all of us have great respect for, both the speakers indeed. So Gayatri, please, the floor is yours.
So I'll basically start with the with the situation that we are all aware of, that the four codes really do not have anything to do with any rights of the workers. Not only did it take away the rights of the organized workers in the formal sector, but it also took away, I would say, did not even give an inch to the unorganized workers, whereas the government kept saying that it is universalizing the rights of workers, both in terms of social security and other protections, which never materialized and which it does not exist as far as the four codes are concerned. The struggles that have taken place, it's not only the struggles of the contract workers. Large numbers of contract workers have come out on the streets, and that's precisely because when you are not given any rights under any of the acts, when you have no way in which you can redress your working conditions, and also with regard to the judicial system, you're not able to get any justice from the courts. The only remedy for workers is to come out on the streets, and that's exactly what happened. So it is going to, in fact, it's not just these struggles, they're going to increase and will have impact on different sectors of the workers. So it's not only the contract workers, as I said, it has, even the domestic workers have come out in Rajasthan. Large numbers of domestic workers have come out, and also gig workers, who are today under the codes not recognized as workers. So I just start with the Social Security Code, and just before I start, I would really, I think the booklet that has been brought out by AILAJ is a very, very inform. It's not just an academic study of the codes, but it really gives practical solutions as to what can be done in terms of the existing codes. So I really welcome this, and I think that we need to spread it to as many unions and other workers in different sectors all over the country. As far as the Social Security Code is concerned, as has been set out in great detail, and I don't want to go into what has already been said, but I would just cover, as far as the four codes are concerned, the general aspects with regard to these codes is one, that basically, if you read all the codes, they talk of it really deals with excessive delegation. That is to say, that all the rights that existed in the earlier acts, those 29 acts, have all been taken away. There's not a single provision where those rights which existed as far as minimum wages are concerned, or as far as occupational health and safety issues were concerned on wages, none of those protections have been carried forward and expanded on. So you have what is known as excessive delegation. That is to say that the courts basically say that it is the state government or the central government that will frame rules, or issue guidelines, or issue notifications. So it's all left for the future without giving any sort of standards as to what those rules and regulations will be. So it's left to the mainly to the central government to issue those notices. So that's one aspect. Second, so it's absolutely unclear, it is vague, it is undefined as to what your rights are. And the second aspect, which is also nicely covered in the book, is the issue of federalism. So when we talk of federalism, we are talking of the uh, rights which the state has and which the central has in terms of formulating or issuing guidelines or legislation. As far as the state is concerned, under the constitution, we have three lists. And as far as state and central is concerned, we have a concurrent list. Under entry 22, you have the state has a right to frame laws relating to trade union and industrial and labor disputes. So state equally has the power to frame legislation with regard to trade union and industrial disputes. Entry 23 talks of social security and social insurance, employment and unemployment. Again, state has the power to legislate on these issues. And then when we look at entry 24, the state has the power to legislate on welfare of labor, including, and this is very important, including conditions of work, PF, employer's liability, workman's compensation, invalidity, old age, and maternity benefit. So it's not just the central government that has the power to do that, the state government also has. And it is in that context that various states had issued and have issued legislation on different aspects. For example, Tamil Nadu has an act which deals with manual labor, welfare boards for different categories of workers. Similarly, Maharashtra has the Mathadi Workers Act, the Security Act, the Security Guards Act, which is really specific to Maharashtra in terms of providing benefits to Mathadi workers who are really who constitute a large section of the unorganized workers. So that is one aspect, and the second aspect is that the codes itself have a provision within them which basically says that whatever law that exists which is beneficial to the workers, whether it's in the form of an act or whether it's in the form of rules or whether it's in the form of an award or settlement, those beneficial provisions will prevail. And that is very important if we want to strategize in terms of how we overcome the deficiencies in the code, that it would help us in terms of formulating specific laws which the state can legislate. So you have under the Social Security Code, you have section 161, which talks of beneficial provisions, 76 of the IRC and 120 of the Occupational Health and Safety, which basically again reiterate the fact that beneficial provisions wherever they exist will prevail over the existing law. The third aspect is that these codes violate the constitutional principles, which we all are aware of, and I don't think I need to go into that. We have Article 21, which basically includes the various aspects to Article 21, and one of which is the right to health and medical care. In a number of judgments, the courts have held that right to health and medical care is a fundamental right and that it should be applicable to all workers. Similarly, you have the directive principles, which basically again reiterate the fact that the enjoyment of good working conditions, the right to dignity at work, the fact that the working conditions should be in such a should be formulated in such a way that the rights of the workers are not impinged upon. These are basic directive principles which basically, again, as I said, reiterate that decent working condition is one of the rights which workers are entitled to. So the courts basically do away with, and when the next speaker also talks about IRC and the wage code, we will see how all aspects relating to wages, relating to working conditions, relating to applicability of labor laws to the unorganized workers, all have been taken away, and there are no specific guidelines as to what those entitlements should be. And lastly, as far as the propaganda that was earlier said by that the propaganda by the employers is concerned and the government, it basically, before the courts came into force, the argument was that it is going to simplify the applicability of the laws, and also it was a universalization of the existing laws that right now are applicable only to organized workers. This argument is absolutely false. As far as Social Security Code is concerned, we find that there are limitations in terms of applicability of the Social Security benefits. What is meant by Social Security benefits is not really defined and specified under the Act, and we know under the ILO conventions that the social security principles basically include 9 branches of laws, and those 9 branches are basically um, uh, I don't think I need to say that, but there are 9 branches which are basically medical care, invalidity, pension, sickness benefit, maternity benefit. All these 9 principles or branches constitute social security, and it has been said both by our constitutional courts as well as by the ILO conventions, that these are basic rights, these are the bare minimum rights which should be made applicable to all workers, irrespective of what work they do and how they are categorized. So when we come to the social security and we see the definitions, under the Act, we find that a large number of workers are excluded, and those are mainly, even if we just very, very briefly go into the basic workers who are excluded, would include one, the building and other construction workers. They're excluded if there are less than 10 workers working on a site. They would not be covered under the law. Similarly, if the construction work that is being carried out is for personal use or personal residential use, and the work is not less than 50 lakhs, then they would be covered. Otherwise, they would not be covered under the Act. So a large number of construction workers are excluded from the benefits of the Social Security Code. Not that there is any benefits under the code, but ultimately under the definition, they are excluded. Similarly, we look at gig and platform workers. The definition given under the Social Security Code is that they are outside the employment relationship. Now, that definition is very interesting because a lot of confusion was sought to be created by the government by saying that gig and platform workers for the first time are included under the Social Security Code. No previous act or law included them, and that is why this law is beneficial as far as gig and platform workers are concerned. But just merely including them in the code does not necessarily mean that they are entitled to the various benefits which are set out under the code. So as workers, they're excluded, and a separate chapter has been set up, which basically says that the government may frame schemes for the benefit of gig and platform workers and for the benefit of unorganized workers. So all workers who are covered as unorganized workers, whether they are domestic workers or whether they are uh, gig and platform workers, they would be covered under schemes that the government will, if they have the wherewithal or the discretion to frame those schemes, they will be entitled. So, under the code, we do not have any definition as to what would be included in the schemes, what sort of benefits will be included, and how and in what manner will those schemes become applicable. That is a major problem as far as the Social Security Code is concerned, and the manner in which a large number of workers are excluded. So when we talk of Social Security benefit, as I said, the ILO basically set out those 9 guidelines. These are the 9 branches which would constitute Social Security. And in India, these 9 branches would include the PF and the ESI Act. So if we look at the PF Act, which provides for Provident Fund, old age retirement, those are the 2 or 3 ingredients under which the ILO has specified that would include Social Security. And if we look at ESI covers all the 9 branches which the ILO set out as a basic and minimum Social Security. So that would include medical care, medical benefits, sickness benefit, injury benefit, survivor's benefit, maternity benefit, etc. Uh, so one would think that when we already have an act, when we already have a PF, when we already have an ESI act, those 2 acts would be made applicable to all workers, irrespective of whether they are classified as workers or not, or they are misclassified and termed as something else besides a worker. Uh, but what the code does is, in order to make sure that the unorganized workers, gig and platform workers, and other workers are excluded from the benefits of Social Security, the threshold limit which exists in both the ES and PF has been continued. All that the government could have done was to remove that threshold limit, which for the PF was 20 workers and 20 workers and more, and for ESI it was 10 workers. So if there are less than 10 and 20 workers, the PF and ESI Act would not be applicable, besides other limitations. So when you talk of universalization, there's no universalization. In fact, it basically excludes a large number of workers. So one is the definition clauses under the code, and the second is the threshold limits that have been prescribed under the code, which takes out a large number of workers from the purview of the Social Security Code. So all that the Social Security Code does is it has two sections, one relating to EPF and the other relating to ESI, which are anyway applicable to organized workers. But even within that, and I need not go into it right now, but if people have questions, even within the EPF and ESI, the central government has really taken upon itself the power to change the rules and change the provisions under both these acts. So it can even reduce the benefits as far as the existing workers are concerned, and that's a very serious situation which unions have taken up. Uh, the the so this is basically as far as the Social Security Code is concerned and the problems faced under the Social Security Code. I'll come to the occupational health and safety, and then I'll complete in 10 minutes. Uh, as far as the occupational health and safety code is concerned, occupational safety and health and working conditions code, it's a very serious situation, because as we've seen right now presently in Chhattisgarh, there was a massive explosion of a thermal power plant, and that plant, there were basically a large number of workers, I think 22 workers died, and several hundreds were injured. And the basic, right now an inquiry is going on as usual. Whenever an incident takes place or people die, immediately the government comes up with a compensation package, and then they declare that a committee will be formed and the committee will look into all these aspects, and that's the end of the situation. After some time, everybody forgets what has happened, and the situation is repeated. So here, basically, the issue that has come up, which the government has tried to hush up, is the fact that there was no proper maintenance of the thermal power plant, of that particular section, which is called the air pump section, which basically has to ensure that the pressure is at a safe and permissible level, and if the pressure increases, that can cause an accident, and which is what happened. The maintenance was not carried out by the factory, and there was a pressure buildup, and the boiler burst, killing a large number of people. This is a recent incident. Several other incidents have taken place over a period of time, and the in fact, instead of looking into these issues with the seriousness that it requires, the code basically does away with all the safety provisions. And I think the report has nicely covered the aspect about the safety provisions having been removed from the occupational health and safety code. So what it does basically is, if we look into the definitions, again, I would just like to cover the definitions very briefly, because the definitions are similar to the Social Security Code, and I don't want to make it too technical, but the important provisions are with regard to the definition of course, of a worker. The worker is defined in a extremely narrow fashion. As I said, gig and platform workers are outside the purview of a worker. So are Anganwadi workers, so are domestic workers, and therefore the proposal in the booklet was that the definition of a worker should be broadly defined. as anyone who is in an employment relationship, which would include gig workers, domestic workers, etc. And also the worker definition has a limiting clause in the sense that it sets out a ceiling as far as a supervisor is concerned. The ceiling is, I think, of 18,000. And so therefore, if a worker earns more than 18,000, now we know that 18,000 is really the bare minimum, even below starvation wages. So if he or she earns, and if the employer categorizes him as a supervisor, and earns more than 18,000, he or she would be excluded from the definition of a worker. Coming to the wages aspect, which has already been covered, I would just add that this is also extremely a dangerous provision, because now the wages definition of wages covers only basic plus DA plus retaining allowance, which is a very small part of the total wages. So you have basic and DA. If we look at the struggles that took place, and I think it's Partha is going to cover the wages, so I won't cover that, but the wages exclusion of several items under the definition of wages has created a situation where workers are barely able to earn the bare minimum, even as far as basic and DA is concerned. As we've seen in the struggles that are taking place in Noida and so forth, the basic minimum wage that has now been fixed is hardly about 13,000, whereas the living wage, what is a living wage, is a concept which will be explained, and I don't want to go into that. So the conveyance allowance, house rent allowance, any remuneration which is payable under any award, etc., is excluded from the definition of wages. And as said, house rent allowance constitutes a major part of the expenses of the workers. If you exclude that, then the wages naturally comes down drastically. So the definition of wages again has its impact on maternity benefits. It has an impact on how you calculate the overtime. It has an impact on your compensation that is payable at the time when you retire. Then you have the definition of contract worker. And just on the contract worker, I just wanted to say that the definition of contract worker has been completely altered, all in the favor of the contractor. So now, earlier, whereas a contractor who had more than 20 workers was required to get a license, comply with the law, etc., now that 20 person limit has been increased to 50 persons. So you have a situation where a contractor will engage 39 people or 49 people, just barely able to show that you are actually not employing more than 50. And in this fashion, a number of contractors, a particular contractor can show his company in one name and some other company in another name and employ contract workers under that different name. So you are able to do away with all the restrictions and regulations as far as contract workers are concerned. And that is exactly what is happening in many companies where workers are not protected at all. And the second part of the definition of a contract worker is that the if the contract worker is working directly with the contractor, then only the contractor will be liable and obligated to pay the due wages or comply with the law as far as the contract worker is concerned. And the principal employer will have absolutely no liability as far as the contract worker is concerned. Now, earlier under the Contract Labor Act, contract workers were protected if the contractor disappeared or absconded or refused to make the payments to the workers. The principal employer was liable to make that payment. Now a situation will be where the contractor can just disappear, not pay the wages or other dues of the workers, and the contract worker will have no um, uh, ability to ensure that those wages are paid through the principal employer. Then the third part of the definition of contract work is the issue of core work, and that is also important. It's already been covered, but I think we need to look at that very carefully, because when we look at all these, the factories that are operating as manufacturing factories, or as factories without or even factories which are hazardous in terms of hazardous processes, the basic element of ensuring safety within a factory is by carrying out proper and regular maintenance. Now, a large number of workers who will be employed as maintenance workers will not be covered under any benefits under the OSH, because they do not form a core of the company's manufacturing process. Maintenance is not a core, and therefore they will not be protected in terms of permanency, in terms of various benefits, etc. So the core concept has really been introduced for the first time here. Earlier, there were a number of judgments which protected workers, particularly with regard to housekeeping work, maintenance work, canteen workers, etc. Now, all that has been taken out of the purview of permanency, or in terms of ensuring that benefits are extended to contract workers. And then finally, we come to the issue of the core issues faced under the OSH. So, what are those issues? One would be the what the courts have done is that they have removed the Factories Act and deleted the provisions which existed under the Factories Act. So there were different provisions under the Factories Act. You had a separate chapter on welfare, you had a separate chapter on safety, you had a separate chapter on inspection staff, and you had a separate chapter on hazardous processes, which was introduced after the Bhopal incident, where a separate chapter was introduced to ensure that wherever companies are engaged in hazardous processes, there would be certain rules and regulations which will have to be followed by the company. And those rules and regulations were specified. I don't want to go into it, but basically, very detailed provisions were provided under the Factories Act. So, what does a code do? It introduces, basically, it has a chapter called which is section 10, which basically says notice of accidents. So if if an accident takes place, the manager or the person occupier must issue notices to the authority. I would say there was supposed to be an inspection staff department, etc. Now they have given the name of inspector cum facilitator. So there's no sort of inspection that is carried out, but basically to ensure that the employer is not prosecuted, is not put to inconvenience by issuing notices to them. So Section 10 is really just a notice which the employer has to give to the company. They are not bound to give it. They are not compelled to give it, nor will the authorities take any action if they do not do. But this is basically a requirement, and it is only restricted to plantations, to building and construction work, to docks, and to mines. But what happens to those where manufacturing process takes place, where the major accidents are taking place? No such provision is provided under Section 10. So a large number of establishments are left out of any sort of regulatory procedure. Then you have Section 13, which basically gives details of what the employer should do. Now, those details are really left to the discretion of the employer. He can decide whether to give a canteen provision for canteen, whether to provide water, whether to provide latrines, whether to provide creches for the workers, whether there should be proper ventilation inside, what is the humidity inside, all that was provided under the Factories Act. Now, under this Section 13, a mere provision regarding duties of employer, as if the employer in his or her good-heartedness is going to provide all these benefits, and if he or she does not, no sort of provision is there to ensure compliance, or what is really meant by duties is not specified at all under this particular section. So we come to Section 18 then, and that again says that standards will be fixed as far as safety is concerned. Now, what are those standards? How are they going to be fixed? What is the procedure in which it should be done? Already the Factories Act, because of its long experience of various accidents or incidents that have taken place over a large number of years, had set out certain standards. There were schedules which were provided under the Act, which basically said what are the permissible limits, say, for example, of humidity inside a factory, or safe in terms of the chemicals that are being used, what is the hazardous limit, what is the permissible limit. All these were specified. Here we basically say the code basically says that standards will be fixed. So again, another committee will be set up. That committee will, according to the government, have experts, which are basically, we know that they are all government appointees, and they will fix the standards as far as the permissible limits are concerned. And then you have the duty of the employer, which again has a very high sounding duties listed out, which really has no meaning at all, because who will ensure that those duties are carried out is not specified at all. And so therefore, then we have the issue of, and I'll stop here, we have the issue of inspectors come facilitators, which again, everybody has talked about this. What the court says is that there will be these facilitators who will whose job is not to ensure enforcement, because that is the job of inspectors. The inspectors have to ensure that certain whatever provisions that are provided for are enforced by the employer, and if those provisions are not enforced, or if the employer does not comply with those provisions, then action has to be taken against the employer. But here there's no question of taking action. In fact, one of the sections says that the inspector or the facilitator will give them another opportunity to rectify the wrong. So, at the risk of causing an accident, at the risk of injuring people, at the risk of even having a disastrous accident in a factory, the employer will not be liable, because he will be given another chance to look into these issues and rectify whatever went wrong with the company. Now, finally, I would just say that ILO has in 2022 held that OSH, occupational safety and health, is a fundamental right. Once this right has been enshrined in the ILO document, even if you have not, even if a member state has not ratified the ILO Convention of 155 and 187. These are specific conventions on occupational safety and health. Even if India has not ratified either of those two conventions, but with the declaration of OSH as a fundamental right, then India is bound to follow those provisions under the ILO, which and I don't want to go too much into detail. I think people should read that. Those are detailed provisions with regard to how safety has to be maintained, welfare provisions have to be maintained, the employer's liabilities, the role of the inspectors, and the provisions regarding whistleblowers and those employees who basically, when they make a complaint to someone, when they make a complaint to the inspector or they make a complaint to the government, the employer immediately gets to know who the person is, and immediate action is taken. This has happened in a number of cases where action is taken against the employer and he or she is dismissed from employment. So therefore, the ILO had set out a provision saying that no employee who has made a complaint should be victimized, no disciplinary action should be taken, etc. We in our code, we do not have that, even though duties of employer has been set out, but none of those duties really protect the workers when they make these complaints. And lastly, we are also signatory to an ILO, which is called the Labor Inspection Convention. Now, this is really ironic that though India has signed the Labor Inspection Convention called in I think 1947, which is number 81, and which really sets out in detail as to how the inspector's role is absolutely important in terms of ensuring that there is safety and health provisions inside a factory. Uh, the inspectors should be adequate in terms of the ratio of the existing companies that exist. There should be a ratio set out in term. Right now, today is a situation in India. We have a problem as far as inspectors are concerned. There's a shortage of inspectors, and therefore the government has said that since there are shortage of inspectors, we are unable to inspect the companies, and therefore the inspection will take place online through a website where the complaints will be registered. Inspectors will not be required to inspect the site. And after a complaint is made on the online, the employer is supposed to respond to it online, and then the inspector will respond online without visiting the site. So you have a situation where the officer will sit in office, look at all those complaints, and decide whether to take action or not. The Labor Inspection Convention very clearly says that there must be adequate inspectors, they should be qualified inspectors, they should actually visit the site and see that that there is proper adherence to the law. Unfortunately, where is the law? There is no law at all. So even if the inspectors went and visited any site, what law are they supposed to comply with? What is the particular section? So this is the major problem as far as occupational health and safety is concerned. And if we look at all the accidents that have taken place in the recent past, we will find that either the inspectors were conniving with the employer in terms of giving them permission when they should not have been given the permission, or in the case of the Mudga fire in Delhi, where a large number of workers were working in a factory, it caught fire, and it was found that no factory plan had been submitted even before the factory started. There was violation in terms of the position in which the workers were made to work. There were no exit or entry doors. There was only one exit, and that is how the workers got trapped inside, and large number of them died. A similar situation happened in Andhra Pradesh, in Telangana, Sigachi, where there was a massive fire. And even though it was a hazardous factory, none of the provisions with regard to following those guidelines under the Factories Act, because under the Occupational Health and Safety, we don't have any provision. But at least under the Factories Act, they should have complied with the requirements of a process which is hazardous. That was not complied with, and about 42 workers died. And again, committees were set up. They found that the factory was not properly maintained. That particular department there was no maintenance done, and yet no action has been taken against the employer. So I will just end here and say that this is an extremely sad situation, that none of these acts really has any provision in order to protect the workers, and the situation in Noida or in other states is going to increase because the rights of the workers do not exist. Whether it's in the constitution, it's on paper, but in the codes it does not exist at all. Thank you.
Thank you so much, Gayatri. I think very tough job you had to try and look at both the codes. But I think really the point that came out it came out very effectively that, this is a government that has abdicated any kind of responsibility insofar as the safety of the workers are concerned in every which way, whether it's in diluting the provisions itself of the law insofar as their safety is concerned, or insofar as the entire this online kind of inspectors Raj that they want to bring in, I think thank you so much for that. There's a lot that you packed in there, and I hope that the audience is listening to you carefully, and I'm sure that there will be some questions that they all have. I now invite Mr. Partha Sarathi, who's a senior advocate practicing in Calcutta High Court. Again, I'm not going to go too much into introductions. We have already done that. Mr. Partha Sarathi will be talking more on the Code of Wages and the Industrial Relations Code. Yes, Mr. Partha Sarathi.
Yes. Here I find
You're audible, Mr. Partha Sarathi. No, you're not audible now. No, you're not audible. You may have to remove your earphones. Am I audible to you? Okay, then the problem's at your end. Just see you're muted. You're still muted. You're muted. You'll have to unmute yourself. The mic still shows. Yes. Speak, please.
yes, you can hear me now.
Yes, loud and clear. Welcome.
Before saying anything on the subject, I would like to convey my thanks to the organizers for this positive step taken by them by publishing a booklet which will be not only relevant for the working people, but even for the lawyers. Therefore, they have done a social duty in this sphere. Secondly, I'll thank Gayatri madam also, because I have been enriched a lot by what she said today. And I'm sure the audience also will be equally benefited. Now I express my apprehension after Gayatri's submission. Really, the expectation has gone so high that I may fall below the expectation level. Kindly excuse me for that. Now, I have to say, as has been told by the moderator, or I have to address you on two codes. One is Industrial Relation Code, and another is Code on Wages. Now, so far as Industrial Relations Code is concerned, that really does omit a number of existing labor legislations. What it does is they have enacted on the plea that the Second Labour Commission has suggested or had suggested that there are so many labor laws. So make a comprehensive legislation. And if this is called comprehensive, I don't know what is more elaborate, in the sense they have simply picked up different acts and juxtaposed them. This is not consolidation of acts. This Industrial Relations Code repealed the Trade Unions Act 1926, the Industrial Employment Standing Orders Act 1946, and the Industrial Disputes Act 19 for the cert. Now here, I have to tell you one thing. When we test whether a legislation is in favor of the working class or against them, we have to keep in mind that the workers' rights contained in this acts did not come just at the mercy or charity of the ruling dispensation or the employers. They had to fight for it. They got it. And therefore, without any valid reason, if those are taken away, then it cannot be said that the act or the code is a beneficial. Two things. A code can deprive a workman in two ways. One is by making provision which will expressly take away my rights. Another is by necessary exclusion, that you are taken out of the ambit of the act. If you are taken out of the ambit of the act, then you are not getting anything from the code. And if the code takes away something expressly, then that is gone forever. Until and unless, again, labor movement compels the government or the employer to see reasons and change it. I just give you a few examples where I shall not take much of your time. Don't get impatient. I shall point out two things. For example, an exhaustive study of these two codes will take hours, if not day. What I say is, it's a Trade Unions Act. There, a registration of a trade union earlier could be cancelled or withdrawn after following a procedure, giving a chance to the union to defend its stand, as also other provisions. If I may just read that provision relating to cancellation. It says a certificate of registration of a trade union may be withdrawn or cancelled by the registrar on the application of the trade union to be verified in such manner as may be prescribed. I understand. The union itself applies. If the registrar is satisfied that the certificate has been obtained by fraud or mistake and that the trade union has ceased to exist or arise or has willfully and after notice from the registrar contravened any provision of this act or allowed any rule to continue in force which is inconsistent with any such provision, or has rescinded any rule providing for any matter provision for which is required under section 6. And third is, if the registrar is satisfied that a registered trade union of workmen ceases to have the requisite number of members. So these are verifiable, and these could not have been done without hearing the unions. Now, what is the position now? I just give an example. If I have to go to all the relevant portions, I can't possibly. If you just go to the relevant portion of the present code, that is the Industrial Relations Code, it says how this can be done. the Trade Union Act has definitely been dealt with, where it says, if I am not wrong, let me assume it for a second that I am not wrong. What is cancellation of registration? It says very categorically, registration of trade union and cancellation thereof, the registrar shall, on being satisfied that the trade union has complied with all the requirements of the provisions of this chapter in regard to registration, register the trade union. Fine, union is registered. Now, where the registrar makes an order for registration, it's accepted. This has happened. But when it comes to cancellation, it says a certificate of registration of a trade union shall be cancelled by the registrar where a tribunal has made an order. Fine. There is an adjudication and the tribunal makes an order. But what is subsection 7? While cancelling the certificate of registration of a trade union, the registrar shall record the reasons for doing so and communicate the same in writing to the trade unions concerned. That means you do something and inform the union. It does not give any opportunity of doing it. Saying that no, you are wrong. Your information has been wrong. Or I have not done anything which is contrary to what is to be done under this code. So it gives the registrar wide power which is not justiciable and which is not in consonance with the principles of natural justice. If I go through the other provisions, you will find that everything is this. But before that, I just make one statement with regard to these acts, these two codes. In my opinion, these two codes are incomplete piece of legislation. Why I say incomplete? If you go through it, almost in every alternate section you will find as may be prescribed, as may be prescribed, as the appropriate government thinks fit. Those are gray areas. No one knows what is there and what is there coming. Therefore, the entire thing is like throwing a stone without seeing what it is. We have to object to it. It is on this code first. That let us know first what you say. Say, for example, as Gayatri Madam very clearly said, that there are three lists: state list, central list, and the concurrent list. So, state can make laws with regard to certain labor matters. But what will be the fate of it? You do not know. Because if that is in any way in conflict with any provision of this code, immediately Article 254 of the Constitution will be taken recourse to, and it will be said that there is a conflict between the Central Act and the State Act. Therefore, State Act has to go. Now, if the State Act is a letter legislation, then it shall be reserved for the consideration of the President, and upon President granting consent, this will become law. I can say two labor legislations which were made in West Bengal but did not ever get assent of the president. So these remain on papers. And if this is to be followed as prescribed without knowing what is going to be prescribed, then you do not know. And there is another thing. We live in India. We are all citizens of India. Therefore, there has to be some sort of uniformity in the conditions of labor and terms of employment. Now, if a court gives power, saying the appropriate government shall, as prescribed by the appropriate government, as the appropriate government may think fit. Now, different appropriate governments may think differently. That will cause a loss of balance as a federal state. It will become really a playing field for everyone at the cost of the working class. Therefore, there also I have my reservation. And so far as provision regarding bargaining council, recognized trade union, sole bargaining agent, all these are not new concepts. The Maharashtra Act specifically spelled out what are these requirements for the purpose of Trade Union Act. In fact, there was a Bengal amendment to the Trade Union Act in line with the Maharashtra Act. That also made provision for these three categories. That means sole bargaining agent, major bargaining agent, or bargaining council. Therefore, this code has done really nothing to clarify where the working class stands. And finally, saying one more sentence about this Trade Union Act, it says that, just 1 second, please. Recognition of trade unions at central and state level, where the central government is of the opinion that it is necessary or expedient that a trade union or federation of trade unions is to be recognized as central trade union. At the central level, it may recognize such trade union or federation of trade unions as a central trade union in such manner and for such purpose as may be prescribed. No norm laid down. So it is the ipse dixit of the central government to recognize any trade union or federation of trade unions as central trade union at the central level, as may be prescribed. And if any dispute arises in relation to such recognition, it shall be decided by such authority in such manner as may be prescribed by the central government. Again, the decision of the central government either to treat a central trade union as a central trade union or not appeal will lie to authority prescribed by the central government, or by such authority in such manner as may be prescribed by the state government. So again, as may be prescribed, we do not know what the central government is going to prescribe, or what the state government is going to prescribe. But it will be really an appeal from Caesar to Caesar. Central government does something or does not do something, a dispute arises, who will decide? By such authorities as may be prescribed by the central government or state government. Therefore, whole thing is really, in my respectful submission, for consideration of all of you, that laborers are being taken for granted in the matter of protecting their rights, in the matter of doing something. So, what I feel is that the central government must, first of all, be compelled to clear this, as may be prescribed, will not do. Prescribe it. State government may prescribe it. Let us see the color of the money, and then we will decide whether we are accepting this or not. This is, in my very humble submission, for the consideration of all the listeners, that it has to be first known and then criticized. First criticism is, it has not made known all these stages. And if I had time enough, I would have read number of provisions as may be prescribed by the central government or state government, knowing nothing about the prescription. And therefore, we are absolutely in dark as to the state of affairs with this. Next is, I deal with Industrial Employment Standing Orders Act. Industrial Employment Standing Orders Act, it says the provisions of this chapter shall apply to every industrial establishment wherein 300 or more than 300 workers are employed or were employed in any day of the preceding 12 months. Kindly see, what was the position in the Industrial Employment Standing Orders Act before this code? It clearly says this act extends to every industrial establishment wherein 100 or more workmen are employed or were employed on any day of preceding 12 months. So, what was 100 now has become 300. That means the scope of the protection of Industrial Employment Standing Orders Act vanishes. Simply in this way, you carve out 200 persons of different establishments, because unless you are 300, it will not apply to you. Now, what was the purpose of this Standing Orders Act there? The purpose was, whereas an act to require employers in industrial establishments formally to define conditions of employment under them. Whereas it is expedient to require employers in industrial establishment to define with sufficient precision the conditions of employment under them and to make the said conditions known to the workmen employed by them. So, an organization or establishment employing 300 or more, their workmen are not getting any protection under this law. Though this law was meant for precisely specifying the conditions of employment of these persons. You don't have to make it known to them. That means you go back to the time when it was hire and fire, because your terms and conditions of service are not known. You go back to the days of hire and fire. Or oral agreement. Under this oral understanding, he was employed. What is his condition of service? As and when directed by the employer. Because there is no standing order. And his standing orders had another check under the Industrial Employment Standing Orders Act. That means there was a certifying officer who could certify the draft standing order submitted to him. And it specifically said the draft standing orders submitted under this section shall be accompanied by a statement giving prescribed particulars of the workmen employed in the industrial establishment, including the name of the trade union. Now, provision shall be made in such draft of every matter set out in schedule, which may be applicable to the industrial establishment, and where model standing orders have been prescribed, shall be, so far as it's practicable, is in conformity with such model. So, standing order must be certified by a certifying officer. Draft has to be submitted to him, and kindly refer to section 4, which says standing orders shall be certifiable under this act if the provision is made therein for every matter set out in the schedule, nothing to be left for future apprehension, and the standing orders are otherwise in conformity with the provisions of the act. And it will be the function of the certifying officer or the appellate authority to adjudicate upon the fairness or reasonableness of the provisions of any standing orders. So, certifying officer or the appellate authority shall adjudicate what? Upon the fairness and reasonableness of the provisions of standing order. Here, at least 100% onwards, they could get this protection. Now, 300% onwards. So it does not take care of the wretched workmen working in small establishments where less than 300 are working. Finally, remember one thing. When we make a change in law of a beneficial legislation, the change should be for the benefit of the working class, not for the benefit of the employer, nor for taking away the benefit of the employees. I understand if the existing 100 would have been made 50, more workers will get benefit of this. But you are making it 300. I see that every employer, whoever may be there, employing any number of persons, must specify the conditions of service of his employees, a workman, precisely, and made known to him. This protection has not been given. Therefore, this is something which takes away the rights of hundreds of workmen who are working. Now, it's a huge subject. Therefore, now let me go to the other aspect. That is Industrial Disputes Act aspect and what changes have been effected there. First, have a look at the and another thing before I go to the next aspect. Section 39 of the code says the appropriate government may by notification exempt conditionally or unconditionally any industrial establishment or class of industrial establishments from all or any of the provisions of this chapter. Therefore, even if it is prescribed, even if it is written, the workers do not have the protection because you live at the mercy of the appropriate government who may exempt conditionally or unconditionally the industrial establishment. Now coming to the Industrial Relations Code. Notice of change is to be given under the earlier Section 9 capital A of the Industrial Disputes Act. And in respect of which, in respect of such conditions of service as were mentioned in the schedule appended to the Industrial Disputes Act. Whereas here, it does not say third schedule is mentioned in respect of the matters. If you just compare the earlier Industrial Relations Code, in fact, this is such a huge code, Industrial Relations Code, that it is well nigh impossible to complete it in such a short time. Anyway, let us see what is third schedule. Conditions of service for change of which notice is to be given. It says all these which were there in the Industrial Disputes Act. In the Industrial Disputes Act. But does not says anything about the ambiguity that earlier existed. In the third schedule. Now, this schedule can be amended. The central government may by notification add to or alter or amend the first schedule or the second schedule or the third schedule. And on any such notification being issued, the first schedule or the second schedule or the third schedule, as the case may be, shall be deemed to be amended accordingly. That means the subjects of condition of service which required a notice under section 9 capital A now can be taken away simply by amending the third schedule. And secondly, every notification issued by the central government under subsection 1 shall be laid as soon as may be after it is made before each house of parliament while it is in session, and if before the expiry of the session, immediately following the session or the successive sessions of the houses, or both houses agree to the modification. Therefore, again, you are going to hands of the party in power or the powers that be, because they have been given this power to amend the schedule itself. Another aspect which requires major consideration is the right to strike, which under the Industrial Disputes Act was there, that you can go on strike, and in case of public utility service, by giving 14 days notice. Where the public utility service, now what has been done is notice is compulsory for every establishment, and the moment thus notice is given, the conciliation officer will start conciliation, and during the pendency of the conciliation, you cannot go in for a strike. Strike was a very sound weapon in the hands of the workmen. The workman could compel the employer to do something or not to do something in course of collective bargaining. Now, you'll say, no, why what strike? It was pending conciliation. You could not have gone for a strike at that point of time. That will be an illegal strike. And secondly, even if you say that yes, I can go in for a strike after this, immediately the efficacy of the strike goes. And the pure logic will say, since the matter has been referred to for adjudication to the tribunal, what is the point or what is the fun in going for a strike? All these are oppressive measures. Why I say oppressive measures? Because the industrial law has grown for these decades, said that the employer's weapon is strike, workman's weapon is strike, and the employer's weapon is lockout. Therefore, the employer, being the stronger party, can afford to go with the government, sail with the government. But so far as workers are concerned, their right is taken away. Secondly, another aspect which is connected with this is, so far as strikes are concerned, we have seen this, but another aspect which requires deeper consideration is since I said something, that layoff, lockout, for that there are provisions in section 67 to 69. But like in the original Industrial Disputes Act, this has been kept, which says that these sections will not apply to industrial establishment, to which chapter 10 applies. Therefore, following chapter, that is chapter 10, will apply to such persons, layoff, retrenchment, and closure. There, earlier, the provision was you have to make an application, I intend to close down, and the machinery provided, they will see whether accounts for closure are good enough to get approval or not. This has been totally taken away. Therefore, and I just read out the provision because law cannot be discussed. Here's the provisions. No worker other than a bodily worker whose name is in master roll shall be laid off by his employer except with the prior permission of the appropriate government, obtained on an application made in this behalf, unless such layoff is due to shortage of power, natural calamity, etc. An application for permission under subsection 1 shall be made by the employer, electronically or otherwise, in the prescribed manner, stating clearly the reasons for the intended layoff. And then, where the workers, other than bodily workers or casual workers, of industries being mine have been laid off under subsection 1 for reasons of fire, etc., etc., shall within a period of 30 days from the date of commencement of such layoff apply in such manner as may be prescribed. This being the situation prevailing prior to enactment of this code, let us see what else has been taken away, because they have come one after the other. See, conditions of retrenchment. No worker employed in an industrial establishment to which the chapter applies, who has been in continuous service for not less than 1 year, under an employer shall be retrenched by that employer until the worker has been given 3 months' notice in writing, indicating the reasons for retrenchment, and the period of notice has expired, or the worker has been paid in lieu of such notice, wages for the period of the notice. This is our earlier section 25F. An application for permission shall be made by the employers in this manner, and the application for permission under subsection 1 has been made. The appropriate government, after making such inquiry as it thinks fit, and after giving a reasonable opportunity of being heard to the employer, the workers concerned and the persons interested in such a retrenchment, may, having regard to the genuineness and adequacy of the reasons stated by the employer, the interest of the workers, and all other relevant factors, by order and for reasons to be recorded in writing, grant or refuse to grant such permission, and a copy of such order shall be communicated to the employer and all the employers.
So sorry to interrupt you.
Yes.
We will have to also, there's going to be a lot of questions also that audience would want to ask.
Oh,
Can
I
I
see.
request you to please wind up in the next few minutes?
Yes. Fine. Fine. In that event, I'm completing 2 codes, right? Code on wages and industrial relations code. So I tell you one thing, as I before starting, I said, this is a vast subject which cannot be covered in half an hour, 45 minutes or so. Therefore, it requires a whole day's exercise. That being so, I appreciate your agony that there will be questions, and the questions will have to be answered to the satisfaction of the persons. So let me stop here and conclude, inviting questions from the audience.
Thank you, Mr. Partha.
Right.
Thank you so much. I think the points that you made, basically, this is an exercise of ousting workers from the protection of whatever law they were enjoying. So the point is that they were enjoying a particular protection, and now they've been ousted of that.
That's right.
And of course, the manner in which federalism stands attacked by these kinds of lawmaking. So thank you for that. There are some questions that we have now. There are some 3 questions that have already come in. If there's anyone in the audience who also wants to ask other questions, please raise your hand, and I'll call you in so that you all can ask it. Avani or Madhulika, will one of you want to go with the questions that we already have?
Just 1 second. A
Yeah.
few questions have already come in. The first question, sir, was how can legal professionals reduce the impact of these codes on workers apart from a legal challenge?
The questions are to all speakers. Gayatri, Madam Gayatri, if you can please switch your camera on. We'll take, I think, couple of questions to both the speakers, which they can respond to. Maybe 3 questions, Avni. We'll take all 3 questions, and then both of them can respond to it. Madam
Okay.
Gayatri? Yes. Oh, you're en route now. Okay. So we'll take 3 questions so that both of you can respond to it.
Shall I just read out the 3 questions
Yes,
then?
yes. You can hear us, no, Gayatri? Okay.
The
All
first
3 questions.
question
She has left.
No, she's with us, but she's
On
traveling.
the way.
Yes.
So she has left the place. Yes.
Yeah.
So
Avni.
the first question again was how can legal professionals reduce the impact of these codes on workers apart from a legal challenge? The second question was, since labor law is mainly judge-made, how will the legal propositions translate? The third question was, excuse me, managements are portraying this as a very pro-labor, impacting them especially in terms of gratuity. Do you think that there's some possibility of convincing managements to also oppose these codes? These were the 3 questions which have come in till now.
Can you just put it
Let
on?
me-
Put it on.
Let me Take the third question first.
Yes.
Don't be hopeful that the management will, on the ground of gratuity, try to join hands with you for changing the code otherwise. Therefore, I don't think there is any prospect of the money management joining hands with you, because they feel the brunt of gratuity as has been granted. Second question was,
Since labor law is mainly judge made,
oh,
how
yes,
do
yes,
legal
yes, I remember.
propositions translate?
Yes. Since labor law is basically law made, very thin Industrial Disputes Act, very thin Standing Orders Act, very thin Contract Labor Act. So everything has come by way of interpretation. That is why it's a judge-made law. So far as the code is concerned, code has kept many provisions intact. Therefore, interpretation of those will not pose any problem. They will be guided by the earlier provisions. But there are provisions which alter the earlier provisions, and unless the decisions which have laid down the law can be shown to be applicable even now, then it will not translate into positive response. And say, for example, the minimum wages, at one point of time, the Supreme Court said, if you can't pay minimum wages, you don't have a right to run an industry. You have to pay minimum wages. Now then, this floor level concept was not there at all. So what you say is floor level, and if you give or specify wages at the floor level, then it is over. So it has been left to the discretion of the appropriate government whether they will go above the floor level or not. That will be a matter of struggle of the workers. Otherwise, you can't get it. And the first question was,
how can legal profession reduce
legal provision?
Yes.
I tell you, legal profession can reduce the load of these courts in this way. One, by creating an atmosphere and environment where the working class will not be misguided by the propaganda that it has given you a lot. And this, when it comes from lawyers, will carry greater and better weight to the working class. So lawyers have said this. This is one way. This is the positive activist way. The other way is, without questioning the law, without challenging the law, in favor of the workman. Many a law has been interpreted so as to bring it in the statute book. So I give you an example here and now. Earlier, this compensation used to be computed on the basis of 15 days salary, monthly salary, otherwise. And what is month? Initially, the feeling was 30 days a month, everyone knows. So the line of thinking was divided by 30 and multiply by 15. So 15 days wages. Lawyers, by their persuasive argument satisfied the courts. Look here, it cannot be so, because workmen do not work for 30 days. They are work at least for 26 days. So you can't say monthly days is for 30 days and they are calculated. It should be 26 days. And that was accepted. And in fact, Gratuity Act was amended by adding an explanation that this 15 days wages will mean 26 days wages. This is how the lawyers have been able to contribute to the reading of the law.
Thank you, Mr.
I
Partha,
hope.
sir. Gayatri, would you like to take a shot at this question?
Yeah, I'll just talk about the first one, about the lawyer's role. I think the lawyer's role is very important in terms of explaining what the codes are and what should be there in the what should be there to protect the workers. That need not necessarily be done through cases and all that. It can be done in the form like what you have done, the booklet explaining it, maybe putting it out in different languages, and reaching out to as many workers as possible, because it's not just a discussion amongst us, but the workers, and that lawyers and activists have to do it together, not just the lawyers. So that's one aspect. The second is when these struggles take place in different parts of the country, which have been taking place, uh, we need to like explain what can be done in terms of the issues that they're dealing with, and how what sort of remedies can be, because it's not just criticizing something. What is an alternative to that? And that we have to put it in a legal framework, but after discussing and collaborating with the workers and their unions. So it's not something in the abstract. I mean, that I would generally say that's the second part is that that as in the case of the domestic workers petition, which was filed in the Supreme Court, a number of organizations were part of it. Lawyers helped in drafting it, but we need to strategize also in terms of when and how to approach the courts, because as we know, the courts are becoming more and more anti-workers. So how to approach, when to approach, all this needs to be strategized with lawyers as well as with the organizations concerned. And the third part is, as far as issues like there might be some issues which the courts might look at it favorably. For example, as in the case of occupational health and safety, if we take up particular instances, like for example, what happened in Chhattisgarh or what happened in Telangana, and collaborate with the local lawyers there by taking up those issues in terms of what should be the basic standards as far as safety is concerned, and maybe to attack those notifications which basically say that you would do it through website and all that. Those notifications can definitely be challenged in court. That's the part as far as the first question is concerned. And the second question is that the third question was about management. How can we collaborate? I agree with Partha that you can't go with the management. I just want to give an example. I attended one meeting of the Chamber of Commerce meeting where all employers had come, and I was supposed to speak on the courts. Of course, they knew who I was, so they gave me the privilege of attacking the courts. But I was listening to them, and there was one contractor who said, "Why should I be responsible for paying minimum wages to the contract workers? I'm not the person who has engaged, who has entered into a contract." And I'm a small timer. I have no money. I mean, these were questions like, I mean, how can you talk and say that you are not obliged or obligated to pay when you're supposed to pay minimum wages? So things like that. And then of course, there were people who said that we are being penalized for not complying, but you have to comply with the law. What I mean, they don't deal with the issues of non-compliance. They just want to be free from being convicted or from being prosecuted under the law. So we can't expect anything from the management people. Yeah.
The second question was, since labor law is mainly judge-made, how will the legal propositions translate now in regard to the new codes?
So that again, I think we have to adopt innovative ways in terms of, say, for example, the definitions that are given in the codes. Wages is defined differently from what it was earlier. Then gig and platform workers is defined differently. What is the meaning of an employment relationship? I think we need to go beyond what existed earlier and to make our understanding of those definitions much broader and innovative. And for that, we need to have more discussions amongst lawyers and activists in terms of, because there were people who said, what do we do now? How do we deal with cases which come up before the Industrial Court or Labor Guide, the tribunals now? So these are things which we need to do either through training or through discussions at a much broader level. Yeah, thanks.
Thank you, Gayatri. Thank you, Mr. Partha. Aditya Krishna has a question. Aditya, you can ask, better if you can ask a question, please. Aditya?
He has got his answer.
No, Aditya asked, he had another question to ask. Yeah, Aditya, please ask.
Uh, Good evening, everyone. So my question was, what do we do as lawyers in cases of, like we're seeing here, mass arrest or general state repression on the right to unionize or the right to protest? We're seeing it here in Delhi, NCR, all around. How do we deal with this? This is not directly a labor law question, but has direct bearings on questions of labor.
These types of situations are to be made on the ground. In fact, I personally believe that legal protection does not come in aid of working people. It always goes with the powers, and therefore it's a struggle where the employees can outnumber the employers and change the situation. Till then, we have to suffer and fight. And legally, you can't have anything more than that.
Thank you, Mr. Partha. Gayatri?
I would just add that I think we need to, because it happened in the case of Noida, where people were contacting us and wanting to know how to get people released. People didn't know what had happened to the people, to the activists who got arrested. And so we had to like struggle and get in contact with lawyers at the local level. We might have lawyers in the cities or in the high courts, but not at the local level. So we need to have some sort of like a master plan or a register with the names of lawyers who are operating in those districts and local courts, so that we can contact them immediately. I mean, right now, this is how I see it.
Thank you, both of you. I think there are no more questions, and it's correctly 8:05. So we've been going on for now 2 hours. If there's no other questions, then I think we can we can stop. We can move towards stopping. I'll just if there's any concluding comments you'll want to make for a couple of minutes each, Mr. Partha, Gayatri. Any concluding remarks, and then I'll.
I just wanted to go to the definition of how the things in the Bangalore water supply has now been taken away from the ambit of industry. This is not beneficial, nor welfare measure. Therefore, such an exercise of exclusion smacks of anti-labor policy.
Yes. Thank you. Thank you, Mr. Partha Sarathi. Gayatri, any concluding remark?
Yeah, I just say that I think that you people are doing a great job in terms of keeping the issue alive. And that's what we need to do. We need to keep the issue alive to counter the narrative of the government and the employers.
Thank you. Thank you, Gayatri. So I think firstly, I'd like to thank both our speakers, Mr. Partha Sarathi and Madam Gayatri Singh, for the excellent discussions, both around the booklet as also around the law, as it were. As also for many of you who have stuck around with us for more than 2 hours now in this discussion. It was not easy, but thanks all of you. I think a kind of we got a sense of the kind of challenges that are before the working class and also us as labor law practitioners. We end, I think it's in order for us to say that on behalf of AILAJ, we stand in solidarity with the protesting workers across the country, particularly in Noida and in Manesar. We condemn the criminal cases that have been filed against them. We condemn the state governments for arresting more than 350 workers and throwing them into jail. More often than not, the families of the arrested workers don't even know which case their loved one has been arrested in and which jail they have been thrown into. We also condemn the kind of brutal tear gas, violence, lathi charge that the police heaped on the workers who are protesting for a basic life with dignity, basic wages, basic working conditions. We also demand that the state government must withdraw all the cases against the workers and release them immediately. And again, I really need to thank the audience, as one of our friends have said, for staying with us for so long. Thank you, everyone. And this report
Thank you.
online now. I request anyone who's interested to please pick it up from the iLog blog, and any feedback from you all is welcome. Thank you, Mr. Partha Sarathi. Thank you for staying with us.
Thank you. Thank you. Thank you.
Good night, everyone. Bye.
Good night. And we call it a day, right?
Yes, yes.